Hi, good morning, everyone, and thank you for joining us for Cordium's webinar today on the newly proposed New York State Department of Financial Services regulations and requirements around cybersecurity. I'm Michael Corcione, the Managing Director of Cybersecurity and Data Protection Consulting Services there at Cordium, and appreciate your time joining us today. I am also expecting one of my colleagues, Richard Hudson, who is a little delayed due to some of the weather here in the Northeast. We are suffering a snowstorm for those of you that may be coming or calling in from other parts of the country. But if Rich does get the ability...
I'm here, Mike.
Oh, good morning, Rich. How are you?
As you said, it's a pretty interesting day with the snow.
Yeah, well, great. I'm glad you could join it. So I was just telling everybody here this morning, you know, my background before joining Cordium involves about 30 years of experience, all in technology around security, operations, focused heavily in the financial services, but also exposure to other sectors based on some of my dealings with our private equity firms. Rich joins us here, and Rich is part of our team, comes to us from over 20 plus years, also all in information security, and a very high portion of Rich's time was spent in the banking industry working directly with the regulators and responding to their inquiries, requests, and reports requirements on cybersecurity concerns. So Rich will be a valuable input to today's dialogue to give some feedback on what the regulators are looking for specifically. And our objective this morning is going to be really to walk through the regulation and take it point by point as the NYDFS has laid it out, share some guidance and some practical advice on how firms can make progress to coming into compliance with the NYDFS. Okay, so with that being said, I believe everybody has seen the instructions on the screen and starting the webinar, so we're going to jump to the first slide. So last September 13th, 2016, Governor Cuomo came out and announced the proposal for the first time, the cybersecurity regulations under the NYDFS for consumers and financial institutions that are under the NYDFS supervision. The initial proposal that was put out by New York State was actually quite rigid and somewhat prescriptive for some of the technology requirements that they were asking the NYDFS firms to implement within their organization. The organizational body heard some of the feedback that was submitted, and they released a revision to the proposal on December 28th that still had some pretty prescriptive terms but addressed the approach of NIST into the regulation so that firms now can take a little more of a risk-based approach when evaluating what they want to put in for their cybersecurity program. I think one of the most stringent, and also as part of that, they pushed the date back 2 months. So the original regulation was proposed to begin January 1st. It's now proposed to begin March 1st of this year. And then firms will have a 6-month period to come into compliance. I think one of the most notable and concerning items for organizations under the NYDFS supervision as part of the proposed regulation is the bullet we mentioned there in the middle, which is going to be the requirement for the organization to submit to the superintendent a certification of compliance. So some individual within the organization, a senior officer, is going to have to sign this certification to the NYDFS beginning January 1st, 2018. And what that means is they're really looking for somebody that has direct visibility not only into the program, but also a line into leadership. Best approach when addressing cybersecurity concerns is an organizational-wide approach. And so having a senior officer really in line with the program's objectives as well as the business objectives for addressing risk is ultimately what will make for a successful program, and of course, very importantly, also satisfy the regulators. So I'm going to move on now to our next slide, which really breaks out the 16 different components of the regulation that NYDFS has put forward. And I won't read through all of these here specifically. We're going to go through one by one as we progress through the slides. But the note here is the 3 categories, as most technology initiatives fall into are the people, process, and technology. And I think probably most importantly is that box under the people 500.04 is the role of the Chief Information Security Officer or third party. So it's not sometimes feasible for firms to have a CISO in their New York branch. It may be represented somewhere else within the organization. And so for those situations, the NYDFS is allowing firms to use a third party to act in the role of oversight of the Chief Information Security Officer. A senior officer from the organization will still have to sign that certification report. You know, one note I want to bring up where I mentioned the branch component versus a global organization. So the regulation is specifically for those doing business in New York and under the NYDFS supervision. If an organization has branches and maybe even the headquartered office outside of New York, there's two options being proposed right now before the regulations being final. And the first, or two, I should say, options that the organization has the ability to take. The first is for the NYDFS branch and that entity itself to adhere to the proposed regulation. And that somebody in that branch will sign off, and the New York branch itself falls under those regulations. They do also have in the proposal the option for the firm, the New York branch specifically, to adopt the firm's global policy for cybersecurity. However, if the firm makes that decision, the entire organization must adhere to the NYDFS regulations. So depending on the size of the organization, strategy must be discussed internally to see what makes the most sense for your firm and what's the most appropriate, and probably more importantly, what's going to be the most effective and in line with what the regulators are looking for. The other two categories that we're going through here, you'll see a lot is around process. So when you're talking about process, that'll fall into areas of your policies, procedures. As we all well know, that's a very favored spot for the regulators to look when evaluating a firm's program. And then the back half on the process side with your policies and procedures is going to be testing and being able to show evidence to a regulator that you not only have defined information security policies and procedures, but a testing component behind that. Rich, before I hop into going into the specific slides, any commentary you want to share with the audience on the overall approach with the NYDFS? I know you have such great experience dealing with the regulators.
Yeah, sure, Mike. Thanks. Basically, as Mike highlighted here, these are the key 16 elements, and there are some that require a lot of input across the organization, and some are specific to technology and tools. But definitely, it's very important to understand what's required from NYDFS. And when it comes to January 15 next year, when someone signs off on that certification of compliance, everything that's done this year has to be in line with these 16 elements. Thanks, Mike.
Yeah, that's a real good point, Rich. So when that sign, that signature has to go on the certification that goes across to the superintendent, that notice, it's basically attesting that your program is up to the regulatory standard and not when you're going to begin bringing it up. So there's really a short bit of time between now and then. I know a lot of firms have already started to take action, but there are several that we have talked to that still really have to get an understanding on how to move forward. And that's where we hope to help those participating in today's call. So as I mentioned, we'll go through these in the identified categories at the NYDFS. So first one is 500.02, a cybersecurity program. And we know a lot of organizations have been addressing information security, cybersecurity concerns for quite some time. But what a lot of organizations may lack or may not have that's in line with what the regulators are looking for is some construct around your program. And so having an outline that everything within the program falls into is ultimately important. Now what the NYDFS has recommended, as well as most of the regulators in cybersecurity, is the NIST Cybersecurity Framework. So many people in the cybersecurity space are very familiar with NIST, and it breaks out to identify, protect, detect, respond, and recover. So as you're going through your cybersecurity program and you're looking at all your risks, how are you identifying your risks? What are you doing to protect your risks? So there are 3 lines of defense for a risk. As mentioned before, it's tools, technologies, those risk assessments that are done up front. The second line of defense is those policies and procedures, as well as the third line being the testing, both parts of the process component I mentioned on the first slide. The ability to detect anomalies, security monitoring being in place to identify if there are any suspicious activities going on with the organization, the ability to respond and recover. So this is ultimately important when the firms really are looking on how they can best minimize the damage. So how you are prepared to respond to an event, and then also the recovery process. So those are going to be ultimately critical in minimizing the damage and minimizing reputational impact. So Rich, you've been working with NIST for years, and we know it's usually the foundational component when firms are doing an assessment, putting a program together. Can you share some feedback on what you've seen around the NIST approach and maybe some suggestions on what's the best way for people to get started?
Yeah, sure. When the framework came out a few years ago, it wasn't too clear what exactly firms needed to do, but in constructing the cyber program, you know, this is a very high-level document, which what the regulators are looking for is to have, you know, like a board-level type document, which highlights those 5 components. So definitely for the program itself, which is not a policy, but a high-level look into the organization on how they comply with these 5 elements. You know, so it's very unique in a sense, but definitely in terms of how these 5 elements are applied to your firm, this is what the regulator is looking for from a high level in this aspect. When you get into the policies and procedures, then it can be expanded into further detail.
I think that's a great point, Rich, to separate the policies and procedures. You know, NIST and utilizing NIST really is a methodology and approach. And so when the firm has to go through, as outlined in the next section in the NYDFS, your cybersecurity policy or policies, right, and procedures that are going to be underlying. So many firms may not have the most updated policies and procedures and requirements in the documentation based on the evolving threat landscape. So first off, it's always recommended that you are internally reviewing your policies and procedures on a periodic and frequent basis and having them updated to address the most recent risks, threats, as you're putting new tools and technologies to make sure that what you're actually doing is aligned with your policies and procedures. And the regulators, when they do come and have to evaluate your firm's cybersecurity program, I cannot stress the value of having good documentation. In the views of the regulator, if it's not documented, you're not doing it. And if they don't feel that you're doing it, it's going to lead to an extended conversation with the regulator. And the better you can do to show a regulator what you're doing as opposed to having to explain it will go a long way. So Rich, in your experience, I know policies and procedures and documentation is really one of your expertise and something you've been doing for the large banks for many, many years. Can you share with the audience, you know, what you've seen when the regulators do come in and ask for those policies and procedures? I know most of your experience, you've been on the good side of when they've come in, but just in your conversations with them and experience, you've seen some of the other side of the table. What can you share with people that give some good thoughts on sound policies and procedures?
Sure, definitely. Thanks, Mike. Definitely when the regulators come in, and I've been examined quite a few times, they ask for policies and procedures. As a matter of fact, with the NYDFS and the FRB, they typically will send a letter requesting the information before they come in. So if you don't have documentation when they come in, as Mike said, you're going to have conversations as opposed to being able to show them what you're doing. So definitely it's better to make sure that whatever is being done in practice is documented. It goes a long way. And here, as this slide is reflecting, these 14 elements must be in the policy. If they're not in the policy, you're opening up yourself to be, criticized by the examiner. So, they're giving you what they're expecting to see. And if it's not in line with this, you could be definitely criticized.
Thanks, Rich. I know we're going to go through probably some of the specifics around testing as we talk through some of the other domain areas, but as long as we're on the topic of documentation around policy, I always tell clients that just having stuff documented doesn't really make you any more secure, but lays the foundation for testing. And a lot of firms will do a lot of testing, but then have a hard time evidencing it to a regulator when they come in. So we know a lot of the documentation they look for is that evidence of testing. Can you just share a couple thoughts there and let people give them some insight on really where the documentation and what you need to capture internally goes beyond just the policies?
Yeah, sure. What the regulators want to see is that in your documentation you're actually doing what you have written. And whether that be, evidence through reports or logs or what have you, they want to see that it's not just words on paper, that there's actual practical execution being done in the firm. So what is expected is to, have evidence that what you have, written is actually being done. And, that goes a long way. So definitely that's something that will be expected.
Great. Thanks, Rich. Sure. Coming into the next section, Chief Information Security Officer. So the regulation would like to see each firm designate a qualified CISO for overseeing the cybersecurity program, or to the extent that's practical within the organization, you can utilize a third party. Now, utilizing a third party isn't going to, as I mentioned earlier, absolve somebody from within the organization from having to sign off on the certification report, but the third party is going to be pretty critical in not only validating what the firm is doing internally, but giving an independent third-party view over the program, and also bring to the table not only experience of what a third party may see in other organizations, but also the latest tools and framework technology being used to evaluate a program. So there are regulator assessment tools that a lot of firms will leverage that will give you a nice deliverable in line with what the regulators will be asking for and how you've assessed your program. But on the role of the responsible parties, in most areas of governance, the regulators want to see that you've identified who's responsible and where the line of reporting goes within the organization. So if you haven't designated a CISO or don't have budget or availability for a designated CISO, somebody else in the firm who's going to have to sign off on that certification to the superintendent should have a direct line to leadership. And usually not the CIO. In some organizations that may be how the org chart lines, but you would want it at that C-level position. Has to be somebody that understands and knows the direction of the firm from a business perspective, as well as how they're evaluating risk. So ultimately, it's very critical and important for the regulators that leadership view be there. And then as what the report is going to entail, Rich, I'm going to let you go through a little bit more of the details, especially on the bottom part. You produce reports for regulators for many, many years. I expect what they're looking in the NYDFS reports are similar to what you've put together in the past, but you can you share with how they are similar and potentially any differences that you see in what the NYDFS is asking as opposed to what regulators have asked in the past?
Yeah, sure, definitely. What the regulators are looking for, and actually 2 points. One, the person who will be signing off for the firm, as Mike indicated, has to understand the business risk and so on. But be prepared to be challenged by the regulators. I've been in circumstances where, as one of the signers, I've been asked to attend meetings with no paper, just a verbal discussion with the regulators to explain certain aspects of the securities posture of the firm. So the person who's signing has to understand that it's a significant responsibility, because they have to understand the business side and also on the cyber side to explain to the regulators. But the report itself has to be an overall posture or view of the firm from a risk perspective. And it should be very high level, like a board level presentation. And it should clearly reflect the threats to the firm, any potential risk to the critical data of the firm, and any potential issues or gaps or recommendations to close those gaps, so that the senior management of the institution can understand exactly what are we dealing with today. So it has to be very, very clear at that high level what the posture of the firm is from a cyber security perspective.
Yeah, thanks, Rich. I think you bring out a really good point where if a firm is going to leverage a third party or use a third party to help with the assessment process and come into compliance with what the NYDFS is looking at, a couple things. One is the senior officer in the organization really needs to be involved in that process and can't just blindly assume the third party is taking care of it and has it covered. Additionally, what that also means is that the third party you use should have some insight into your business, and that they can relate to some of the business aspects in regards to cybersecurity. So there's a lot of technology firms out there and a lot of organizations doing cybersecurity. In some cases, it's a combination of bringing multiple third parties to the table and bringing the best of breed where needed. So an organization, a third party to do the assessment would be helpful for one that understands the risk of the banking industry or your specific organization's requirements. And then where areas are required around specific technical tools and technology, bring in the best of breed there, but let another third party really carry that role of messaging to leadership within that organization so that you can get a best representation from the technology side as well as on the compliance side related to your specific organization. So, coming into the next domain category, penetration and vulnerability assessments. So these are two components where I mentioned that prescriptive guidance or regulation requirement that the NYDFS has put out is penetration and vulnerability assessments. Both are very helpful for identifying weaknesses within your organization's information security program. I think what happens here when running a pen test and doing vulnerability scanning is ultimately going to be the reporting that comes out and the interpretation of that reporting. And this kind of leads into what I was talking about on the previous slide, where you'll have somebody that's really good on the technical side from a penetration standpoint, but may not understand the business side. So when running through a pen test, they may come out and categorize the vulnerabilities they found as low, medium, and high, but without the proper perspective from the business view and interpretation of the report. Some things may not be classified as in line with the way leadership of the organization would see it. So Rich, I know you've reviewed hundreds, maybe thousands of vulnerability tests, vulnerability scans and penetration testing reports. Can you share with the audience, a little bit of your experience on conducting that process, working with the vendors, and then ultimately how firms can best digest the information they get from those reports?
Yeah, sure, definitely. The key with the penetration testing, and I'll start with that, is it's highly recommended to use an outside party to do this. And every year that the test is done, the outside party should be different. And the thing with the penetration testing is that both the internal testing and the external testing should be done by the same party. It doesn't have to be, but it's better from what the results I've seen. And the key also is when the testing is over and the results come back, that the firm really analyzes the report, because some of the findings or recommendations in terms of the level of risk may not apply to that firm. So if the vendor says, you know, you have an issue with your firewall rule base and it's a high issue, you know, there may already be some mitigation in place where it's not a high issue. It may be a high issue for the market, but for your particular firm and the risk to your particular firm, it may not necessarily be a high issue. So the report has to be analyzed in detail to make sure that the findings are really practical and applicable to your firm. On the vulnerability assessment side, this is also where you do your scan, whether it be a tool like Qualys or what have you, you get your results. Again, you assess it. You look at your environment to see if the results reflect the level of risk that a report is suggesting. And then you take it from there. And then one of the key things which Mike will get to in a few slides is that if you do have issues, you then have to track these issues until they're resolved. And that's a separate process. So with that, I'll just turn it back over to Mike.
Yeah, thanks, Rich. And coming into the next slide, tease it up well. So the audit trail. Few things in this, or actually I guess a lot of things when you're looking at the audit trails and what the regulators want to see. So all your systems are generating some type of log, audit trail, reports that can be looked at if there has been some detection of unauthorized access to the systems. So what the regulators want to see is not only are you capturing these logs, but that they're being stored properly and that they are periodically reviewed for tampering, for any malicious type activity. And then ultimately, as you move through the assessment report, one of the things that you're going to be doing is how you're going to track all the activities that you're going through and remediating and having discussions around, and the prioritization activity that you're doing. So that leads into really, as we mentioned before, the testing component of your policies and procedures. What evidence are you able to produce to show that you're doing these things? So they'll want to see that you have records that are going to show you not only captured the logs, but that somebody went through and reviewed the logs, and that it's somebody that was competent to review the logs, and where those logs were reviewed and generated certain alerts and signals, what was the follow-up? So not only is there evidence that's captured, but also some workflows that may need to be tracked, and displaying to the regulators in a system of some sort on how you are, you know, a GRC type solution, a governance, risk, and compliance type solution, software tool that allows you to align not only your policies and procedures with the activities you're doing, but the evidence that you're capturing, and then ultimately how you're reporting on the progress of your remediation efforts and reducing risk, and reporting that up to leadership. So Rich, you've dealt with a lot of these logs and trails and know very well how valuable they can be to an organization, especially at the time of a cyber incident. Anything specific you want to share here on audit logs, trails for the attendees?
Yeah, definitely. One of the key things here, which is not clearly stated by NYDFS, is that they know many firms may be using spreadsheets to track issues and, you know, resolutions and who's the assigned person to resolve it. They're actually looking for firms to have a system. You know, so if an examiner comes in after January next year and says, show me your audit trail process, and a spreadsheet is presented, that's going to be a red flag. You know, they're looking for automated solutions for tracking issues. And that's something I've experienced, and definitely there's something that firms have to look at in the next few months. Definitely it has to entail very clearly the issue, who's assigned to it, target dates, and so on, to make sure that if a third party or another set of eyes looks at the report or the audit log, that it's very clear from start to finish how you track and address issues in the audit system.
Great. Thanks,
Yeah, one
Rick.
other thing.
Oh,
Yeah,
ahead.
sorry. The last point, which talks about the not keeping the logs for not fewer than 6 years, that's also very important. So, you have to plan for collecting at least 6 years worth of data when it comes to logs. So this is where a system has to really be put into consideration. A spreadsheet, which most companies may have in place, is going to be a red flag for the regulator.
Great. Thanks.
Thanks, Mike.
So the next slide we're going to go to is definitely one of the favored areas for the regulators. What they look at is your access rights and the privileges. So who has access to the data? Who can touch it? Who has authority to see certain files? And usually what happens in organizations is there tends to be a lot more liberty in providing access to information to accommodate the business achieving what it needs to do. And people are wearing multiple hats at times, or covering for people that are on vacation, or at times people just feel it's better if they have access to information just in case they need it so that they continue working. But really what is the best route when it comes to access management is the principle of least privilege. So people should only have access to information that is ultimately critical for them to perform their day-to-day functions. The less they need to use the data, the less access they should have. If somebody needs to have access to data once a month, it's probably a better practice to not provide them access, but have them go through somebody else that uses that data on a daily basis, provide it to them. It's a much more secure method. And so when firms start talking about access privileges, we kind of look at it as the crown jewels discussion and your most sensitive data within the organization. And really only people that are required to have access should have access. And the other thing we'll also look around when your access rights are is the management process to provision access and also remove access, often called the joiners, movers, leavers program. So when somebody joins the organization, usually there's an onboarding process through HR. That should be solid, it should be reviewed, and all lines of authority that need to be involved should be represented, right? So the onboarding seems to be the easiest for organizations. Where sloppiness comes into play or things get a little more loose is in the movers, as we call. So when people are changing roles within the organization, somebody may assume a new role but still needs to keep access to the old stuff that they can support the new person they're training. And so where is the oversight to make sure that once they are done with that previous role and the responsibilities have been handed off, that the access has been removed? If they no longer need it for the day-to-day responsibilities, they shouldn't have that. And then the third area comes into the leavers. So when somebody is terminated from the organization, whether voluntary or involuntary, that there is not only a comprehensive but an extremely prompt action coordinated with HR and other responsible owners of data and systems within the organization to make sure that the access is removed promptly, and then also that process is reviewed as well. Rich, your thoughts on the access rights and how regulators will look at this area?
Yeah, sure, thanks. One of the things the NYDFS is looking for here is good control over movement of individuals who have access to the data. It's expected or certainly recommended to have an IAM system, Identity and Access Management System, in place. It helps to manage the entire process. So that's something that firms should keep in mind. And if it's more of a manual process, the regulators could recommend that firms look at implementing an identity and access management solution. And there are several in the market, but definitely they will be looking for more automation of this process.
Great. Great. Coming in the next bullet under 500.08 is the application security. So where firms have custom developed applications internally or externally, the organization is going to be responsible to make sure that there is secure software development processes and procedures. So not only when the software needs to be updated and revised, that also just the general maintenance going on. So your change management procedures, your development procedures, all need to be in line with the best security practices. So if a change is made, what are the proper change requirements? What is the user testing environment before new code is rolled out? And what are the code reviews that are being done? I've seen over many, many years of experience dealing with departments that have application developers that they tend to be some of the more liberal thinkers in an organization for freedom and flexibility, reaching out to grab pieces of source code, open source code that they can leverage, and sharing amongst peer groups some of the strategies and techniques that they're using. All of these can create vulnerabilities not only in the process but also into the exposure an organization has. So it looks like we've lost one of our slides. We're just going to hop back. Overseeing that internally, or if you're using a third party from an extra that's developing an application for you, making sure that you're fully aware and of what their application security processes and procedures are, and that they're up to speed. Rich, any thoughts you want to share on the application security section?
Yeah, sure. Thanks, Mike. For the application security, basically, the regulators are looking for a clear document process of an application lifecycle, basically, from initiation to deployment and maintaining the application. So that the process, the procedure should include everything from a security perspective at those different phases. And that doesn't only apply to internally developed applications, but also externally developed applications, or even applications that are developed internally but hosted in the cloud. So the procedures have to reflect for that entire life cycle of the application how the security is applied in all phases. Thanks, Mike.
Great. So the risk assessment section, a lot of firms have conducted risk assessments already. You've done it internally. I think a couple items here on this that we mentioned is, a risk assessment, a good risk assessment should do an evaluation of the business risks, threats, and potential impacts. Should also have an element to review the firm's inherent risk based on their connections, their vectors, their technology footprint. Also should have a component that identifies the gaps and maturity across their information security controls, and then ultimately should have some output of a strategic plan, some approach that you're going to look to reduce risk and mitigate some of the gaps that have come up through the assessment. Without a plan, it basically looks to the regulator that you've done a snapshot as opposed to really having a proactive program that's moving forward. Rich, anything specific you want to add on the risk assessment process?
Yeah, sure. One of the key things with a risk assessment is that it has to be very thorough. There's some risk assessments which are pretty high level, but what the examiners are looking for in this particular item is to do a detailed assessment on not just your logical security, but also your physical security. And the reporting that's required to the board of directors, senior management, which is twice a year, should be the results of this risk assessment. So it's very important that the assessment captures the entire firm's risk posture from a security perspective. And there are several ways to do it, but it definitely has to be very detailed. And the reporting would then summarize the results.
And I think two things you mentioned there. One is there's a lot of ways to do it, but also, something that the regulators will recognize. So using the proper tool, and industry guidance. So NIST, as we mentioned before, is a methodology, but there are specific defined frameworks. There's one by the FFIEC, Federal Financial Inspections Examination Council, right, which will help and really identify what the regulators are looking for specifically, and then the output aligns, as I mentioned before, what they're looking for specifically. So just a few more slides as we're coming in towards the tail end of our time. Next one we're going to talk about here is cybersecurity personnel and intelligence. This one, pretty much straightforward. What they're looking at is what are the people that the organization has? Do you have defined roles and responsibilities? Are people competent to facilitate that role? Is the organization making sure that they're providing the staff the appropriate training and knowledge that they need to execute on that role? And then also where you're looking on the intelligence that firms want to do is what are you doing to understand the threat landscape? So everybody sees the headlines in the news every day that are talking about different attacks, different threats, but there are specific services that firms can subscribe to. I think one of the most popular is FSISEC, which is the Financial Services Information Sharing Service. There is also MSISEC, which is a free service, multi-state. They'll put out daily bulletins, briefings, things they're seeing in your industry, alerting you to the latest types of ransomware that may be out there and spoofing attacks that the criminals and cyber attackers are looking to penetrate organizations. So there are multiple ways to get threat intelligence. As I mentioned, a couple of the services you can subscribe to. Peer groups are also very helpful to learn what your peers are. But basically, the intelligence is one of the real key components for a good cybersecurity program so that you can stay ahead of the curve and be more proactive than reactive. Rich, your thoughts on the intelligence side?
Yeah, definitely. The regulators are expecting financial service firms to be involved or members of information sharing entities. So FSISAC is one of the recommended ones, and one of the reasons is that every year in October, around that time frame, which is Cyber Security Awareness Month, they have an annual drill. They perform a simulated test with the participants who subscribe to their service, and it's very good. I've had regulators ask firms, have you participated in the FSISAC test? So it's definitely recommended to join some of these entities, especially it's expected that you're a member of FSISAC.
Great. Thanks, Rich.
Thanks.
I'm going to come to the next slide, and we are bumping up on the timeline here, so there is a lot on this slide here about the third-party information security policy. So much that we actually have another webinar teed up 2 weeks from now that you've probably also seen in the invite on February 22nd that is going to go specifically into the vendor and third-party risk. Couple quick items to note here on your third party. You have to have a vendor risk management policy, something that clearly explains how you're risk rating your vendors so they're not all equal. Your higher risk vendors will require a deeper level of due diligence. What type of information are you capturing from these organizations? How are you saving that information and showing the workflows of how you've gone through the process? I think also one of the things here to know around the third-party providers is the regulation proposed by NYDFS is not only putting the notice for those supervised by NYDFS, but all service providers providing services to covered entities are required to have at least the minimum level of cybersecurity policies, procedures, and program requirements, which would align to the same as the organization. So you would never want to use a third party that had weaker cybersecurity program than yourself. So in essence, if you are adhering to the NYDFS regulations, so should your third-party service providers. And as I mentioned, we're going to have a full webinar dedicated specifically to this topic. So we don't want to go through every bullet here on this, but Rich, I know we're coming up towards the tail end of the top of the hour, but any thoughts you want to just throw in quickly on third parties and vendor risk?
No, I think you covered it for now, and definitely when we go to the next webinar, we'll get into more detail.
Okay, great. Thanks. Multi-factor authentication. So a lot of people may consider this an annoyance, but it is probably one of the real good things you can have in a security program, and that's why specifically the NYDFS is calling out and requiring multi-factor authentication for any individual accessing the firm's internal systems or data from an external network. And that requires your third parties. So having some method that it's going to be able to verify that user in at least the two-factor is going to be a requirement. So this is an area where firms should probably prioritize the efforts because it is going to require specific tools and technologies put in place. Rich, your thoughts on the multi-factor?
Yes, definitely. It's something that the examiners will look for. If you have just a single authentication process, it's going to be a problem. I mean, hackers love that. So with the multi-factor authentication, like secure ID is our recommended solution, but again, it depends on your organization and your level of risk. But definitely, it's something that we've highlighted here, as so has the NYDFS, that firms really have to look at.
Great. Okay. Coming into the next slide, limitations on data retention. So the financial services industry has been way ahead of the curve on from a lot of other sectors in regards to retaining data and the requirements that are put there. But what also comes around is not retaining data. So making sure that you have a proper destruction policy benefits a few things. So the people, and it's really specifically going to be around that, non-public information within the organization. But the two sides on it is it's asked by the NYDFS or being put in the regulation that you're disposing it to protect those whose information you hold. And from an organizational standpoint, you don't want to hold any of the data longer than the law requires you to. It's just an extra liability on the firm. So not only making sure that your databases are clear of the data in a timely fashion, but also that any other areas where the data may have wandered is also not in those. So it's kind of a couple areas that you look around, probably focus primarily around your efforts around your data classification policy, and then also how you're using tools within the environment to sweep certain stores and validate that this non-public information or personally identifiable information from consumers is not stored improperly. Rich, your thoughts on the data retention component of the NYDFS?
Yeah, sure. The key here, I think, with this slide is if you get a subpoena, which you don't want to get, because at that point, if you begin to do the destruction, as opposed to litigation hold, you could be in some trouble. So the idea here is that you have a firm policy on how you retain data and how you destroy data. As we said in the very beginning, you have to make sure that you're actually doing it. And if you're asked to provide information that has been destroyed, you're fine because you're following your actual documented and approved policy. Thanks.
Great. So just 4 more bullets that we're going to go through here from the NYDFS. The training and monitoring. So 2 components. Monitoring of activity around unauthorized access to data or systems. There's a lot of tools and solutions around monitoring today. Some of it is pretty advanced, so user behavior analytics is a pretty popular term out in the cybersecurity world, and very helpful solutions and tools to really get a predictive approach as to a potential breach that may happen. So if a user's normal activity is between 9 a.m. and 5 p.m. and there's somebody logging in outside of that window or anomaly from their normal behavior, alerts go off. Now there's also manual ways or more procedural type activities that you can do internally as opposed to putting in tools and solutions, such as surveying emails and other things. But what the advanced solutions do is actually bring up alerts to really help you determine when to monitor. But the oversight on all your sensitive data, critical systems, now should be ongoing perpetually. And then on the training aspect, there's never enough training. The attackers know the user is the weakest link in the organization. So there should be awareness training, there should also be policy and procedure training, and there should be basically training around what are the threats out there. So it needs to be updated. It needs really in a good program to be more than just once a year. And so also, how are you following up and testing that your users have understood the training? And there's various tools and solutions you can use behind those activities as well. Rich, your thoughts on the monitoring and the training?
Yeah, the only thing I have to add to what Mike just said is that the examiners are looking for evidence of training. So many times what I've experienced is that they ask to see the attendance ratio. They know the amount of staff in the firm. They're expecting 100% participation. It's very important to track the attendees and be able to provide that report if requested by the Fed or DFS.
Great. Next one's going to come up around the section of the encryption of the non-public information, which really falls back into, and a lot of items around data tied to your data classification policy, but really having an understanding of what you're going to encrypt, how you're going to encrypt it, and then where areas where encryption may not be feasible, what are the other types of mitigating controls that you're going to put in place and alternative solutions. Rich, your thoughts on the encryption requirement?
Yeah, again, it's definitely being more by the regulators to make sure that non-public information is encrypted. There's so many solutions in the market. They are making sure that firms comply with this requirement. So it's very important to understand your environment and where the data exists and actually how it's protected. And if you have to explain that to the regulators. Thanks.
Right. Next slide. This is one of my favorites from an importance perspective and where I tell firms you probably can get the best bang for your buck. It's around incident response. It ultimately minimizes your damage. And so incident response, a lot of people will automatically start thinking we have a disaster recovery plan, we have a business continuity plan. Cyber incident response goes a step further. So if there's a cyber incident that goes on, the first event is the technical event, which kind of ties into BCP and triaging what's happened. But everything else after that is on the business side. So when do you have to notify potentially if you do regulators, if you've had a breach? When do you have to notify law enforcement? When do you notify employees? Or do you notify employees if you've yet to determine if it's an inside job or something externally? When do you reach out and bring in your cyber insurance company if you have a cyber insurance policy? So these are all the aspects that the business people need to talk through, and a good incident response plan from a cyber perspective will have defined some high-level scenarios, not ones that go exhaustively through what you would do, but here's a high-level scenario, an example of ransomware or a data breach or a DDoS event, and then what would be the communication discussions that you'd have, who is brought to the table, when are they brought to the table, and even some pre-canned scripts on how you may need to communicate publicly or working with a PR firm is going to be helpful to get a sense beforehand. And so this way when the event happens, you can communicate efficiently and effectively. And then of course the plan should be tested. Rich, your thoughts on the incident response?
Yeah, one key thing with the incident response to bear in mind is most firms will be required to look at hiring an outside firm for forensic purposes. In the event that an actual cybercrime has been committed based on the incident, there may be, having to go to a court of law. So it's best to bring experts in who do this. And a forensic firm can be retained at no cost. There are many options out there, but definitely it's something firms really should be considering.
Yeah, I think that's a great point, Rich. When the crisis happens, nobody wants to have to go through terms and conditions of a contract and the lawyer back and forth. So getting that settled up front can really save a lot of headache. So we're down to 1 minute left, and we have one slide left. And actually, I noticed that everybody has stayed on through the entire webinar, which we appreciate and understand that it's some valuable information, and hope we're really providing you some good guidance to what is going to lead into the requirement on the slide now, which is the notices to the superintendent. this is going to be the component we mentioned up front, where somebody is going to have to sign off a certification of the program, adhering to what is laid out in the regulations, that you are complying with the regulations, and that you thoroughly understood what the regulators are asking for. Rich, I know this tends to be one of the most scary components. Any thoughts you can share with our audience on how this may be less scary for them?
Well, the thing is a combination of, as we said throughout the webinar, understanding your business risk and also understanding the cyber aspect to it, and then be able to explain it if asked by a third party, especially the regulators. So, you know, with this particular slide, the notice to the superintendent is very important because they're expecting that the person that they will come back to ask questions, which is a senior level person, has that knowledge and understanding. As I said, I've been called into meetings just by myself in the past, and you know, that's what they're looking for, to make sure that the firm is up to speed and up to par with what they're expecting from all these elements we just discussed.
Great. Thanks, Rich. Appreciate everybody's time for joining our webinar today. I know we are right at the top of the hour. I do want to put out if anybody would like to submit some questions. And we'll give just a moment. If you go over to the box on the right-hand side, there's a location there where you can hit the button to submit a question. And they have one that's popped up where people are asking more about specific tracking tools and does SharePoint work effectively. You know, SharePoint is a pretty good tool. It's definitely much better than the spreadsheets that Rich has mentioned, and facilitates a lot of what the regulators were looking for. The manageability is always going to be determined based on the user's ability to understand the solution. But what is going to be more helpful is really something that's going to have workflows built into it, and things that are going to be a little bit more on the fly, also have recurring reminders. Something in a calendar-based type solution is probably going to be, you know, a little more effective in, you know, some of the expanding requirements. You know, when you're dealing with policies and procedures that can be somewhat extensive, it's a lot to track. It's a lot to stay on top of. So having an effective tool and solution in place will really go a long way in managing the product. We're just going to check and see if there are any other questions coming across. Other one is coming back asking me to repeat when our vendor risk management webinar is. I know it's in the invite. We hope you've all signed up for that one. It is on February 22nd at 11 a.m. What we'll be going through there specifically really is from having a defined, as I mentioned earlier, vendor risk management policy. What are the components in that policy? What are the categories that you would use for risk rating a vendor? As we mentioned before, they are not all created equal, so you want to make sure that you are applying the appropriate effort alongside with what the appropriate risk is for that vendor. So that being all we have for today, no more questions coming through. I want to thank everybody for their time and joining us on our webinar, and look forward to having everybody once again join us on February 22nd, 11 a.m. for our third-party and vendor risk management webinar. Thanks, Rich, for your time. I appreciate your support.
Thank you, everyone.
Great. Have a good day, everybody. Thank you.